So, Mr. Moore, on behalf of plaintiff Tamara Gilson, you may proceed with your closing argument.
Thank you, Your Honor. A week and a day ago, we all met one another for the first time. You were sworn in as jurors, and ladies and gentlemen, before I get into the facts of the case, I'd like to talk to you for just a moment about what it is to be a juror from the perspective of a trial lawyer with 35 years' experience. When you raised your hands to become jurors, you joined a line of select few in an institution with a history of over 1,000 years. When Tom Jefferson was penning in that blistering summer of 1776 in Philadelphia the Declaration of Independence, jury trials were already 700 years old. The Englishman who created the jury system created the most important and responsible institution in our government. When we're a great country and we have great institutions, but ladies and gentlemen, when Congress can't decide which side of the hemisphere the sun comes up, and when the executive is paralyzed, and when bureaucracy's wheels come to a grinding halt, then the last best hope for victims of injustice lies with the jury and lies with you. You should be proud of what you have done and what you will do. And even those two of you who may not be deliberating with the other jurors, you should be proud of what you've done. That's why I'm proud to be a lawyer who prosecutes cases on behalf of people like Tamara Gilson. I have that privilege and that power. And I can say on behalf of Tamara that from the bottom of her heart she appreciates and thanks you for the attention that you've paid in this case. Now, you've heard this part of the case called closing argument. But ladies and gentlemen, I don't have the gift to persuade you. I'm not Ronald Reagan or Bill Clinton. Maybe if I was somebody like that, I could persuade you. I'm not that kind of lawyer. I haven't that gift. All I can do is bring to you the facts by asking question after question after question. And if the answer is not complete, then I ask another question until you have the entirety of the case. Now, we're not here to decide a popularity contest. This isn't American Idol. Ladies and gentlemen, if your decision was based upon which lawyer or which party you felt was more likable, then we just tear this building down. Nor is this inquiry into the character of anyone, and that's important. That's important. We're not talking about character. We're talking about perception, intention, and action. Perception, intention, and action. And why do I say that? Ladies and gentlemen, people who are not bad people can do harmful things. We're not here to determine what the character of Diane Sater is or anybody else. We're here to decide what she did, what her perceptions were, and what were the intent behind those actions. Now, one thing that was never at issue here, ladies and gentlemen, is the injury that Diane Sater, the defendant, inflicted upon Tamara Gilson. Whatever the legal consequences in your minds of her actions, she has not even tried to suggest that in firing Tamara, she didn't cause her great grief. She's not suggested that she didn't cause her to lose 8 months of income because she had to find another job without any warning. She's not denied taking Tamara's good name, nor has she tried to suggest to you that she did not inflict humiliation on a woman at the close of a career of outstanding achievement. That issue is not contested in this case. Now, as a lawyer, I have an awesome power, but think about this. My power pales before that of a nurse. Why? I ask questions if I make a mistake, nobody dies. If we are unfortunate enough to be treated by an ill-trained massage therapist or acupuncturist, all we lose, ladies and gentlemen, is the fee that we paid that person. But if a nurse miscounts pills or misreads a chart or picks up the wrong IV bag, a family can be gathered in grief at an open grave. Why is that significant in this case? Because when this case boils down to two competing philosophies. The first philosophy is represented by Tamar Gilson and Darcy Kaplan, who you heard, and Dwayne Landrum. And that philosophy is that if you aspire to be someone with the power to hold life and death in your hands, then you must earn it. You must earn it. You must work, you must educate yourself, you must be committed, and you must be disciplined. That's the philosophy behind the Ohio Board of Nursing. But what was a culture that is opposite that clashed with that? What's the culture? It was said last Thursday morning by Mark Sullivan. It was probably said best. Mark Sullivan said that the culture of AIAM, the philosophy is customer service. And who are the customers? Customers are not the patients in whom the lives of these nurses will be entrusted, but the students themselves. You know, when I was discharged from the United States Air Force so many years ago, I can't recall, I went to work for my father-in-law's restaurant, and my father-in-law explained to me what customer service philosophy was. We've all heard it. The customer is always right. In this case, you've heard the evidence that shows that when Tamar Gilson and Darcy Kaplan and Dwayne Landrum and the other folks at this school attempted to impose requirements on applicants and students to make sure that they could be trusted to be good nurses, that they were overridden by the defendant. Overridden because that type of thing did not put the bodies in the seats. Now, I was unable to speak to you in opening statement when I presented you with a story in two parts. You probably all recall that story. And I told you I was committing to you that I would bring you the evidence that would fill in that story. And I believe I have. We now have the framework by which you must make your decision. It is these jury instructions of 13 pages. And Judge Waters is going to be giving you those instructions when myself and Ms. Miller are done. But although there's all these instructions, they boil down to two simple propositions. Did Diane Sater, was her motivation to terminate Tamar Gilson in any way based on age? And did she lie about Tamar Gilson's alleged senile dementia? You know, the defendant conceded in her testimony that by October of 2012, she considered Tamar prickly and inflexible. And she also conceded that she considered her prickly and inflexible because she insisted on the standards being high. When she overrode the decision that was made in June, that is found in Exhibit 31, that document that's the Curriculum Committee report, when she overrode that decision in October, she did not even inform Tamar Gilson that she was doing that. This is the woman who had to respond and educate these nurses, and she wasn't even informed that the standards would not be imposed on these incoming students. I would submit that the evidence conclusively shows that Tamar would just not get with the defendant's philosophy of customer service. As Dwayne Landrum testified, when after Tamar was fired and Diane Sater and Helen Yee came to him to ask him for help in finding a new NPA, Helen Yee said, "We want somebody young and energetic." You know, when we hear someone say that another person is too old, that perception is not in a vacuum. And what I mean by that is, somebody doesn't say, oh, so-and-so is too old. It's always, so-and-so is too old for something else, isn't it? And in business, ladies and gentlemen, the way we hear it is that so-and-so is too old to change. I mean, it's everywhere in our society. You can read it anywhere. I was reading this just the other day. It says, just because overt age discrimination is illegal doesn't mean it never happens. In 2011, Google settled a multi-million-dollar claim brought by a computer scientist named Brian Reed, who'd been fired when he was 54. Reed said colleagues and supervisors had frequently referred to him as an old man, an old fuddy-duddy, whose ideas were too old to matter. These, ladies and gentlemen, are stereotyped views of people. And the question in your mind is, did the defendant come to view Tamar Gilson as old in a stereotypical way because she would not get with the program? Which brings me to the next point. When you consider credibility and you consider whether or not the defendant engaged in a pattern of behavior intended to drive her out, think about this. Within weeks after discharging Tamar, Diane Sater and Elaine Hyatt had hired a completely new NPA, had hired a full-time clinical counselor, had hired a half-time assistant, and had hired 3 master's certified faculty members. I submit that you consider that in the context of the fact that in October, when Tamar Gilson asked Diane Sater, and this is in Exhibit 40, asked Diane Sater to allow Darcy Kaplan to come back, and remember this, to finish the winter quarter schedule, that Diane Sater said, no, I can't do it because Darcy Kaplan's too expensive. It costs too much. And then what was the reason given by the defendant for her termination? We've heard a lot about forgetfulness and all that, but you heard Elaine Hyatt say in her testimony that the triggering event was the failure of Tamar Gilson to complete the winter quarter schedule. So they denied her the woman who would have been able to support her in doing that, and now they blame her for not having completed the schedule. Defendants put on testimony in the case that the outcomes, they say, for the students were better after Tamar Gilson left than when she was there. So the students are happier and more satisfied, and I'm sure the students are happier and more satisfied with the customer service philosophy because they're not required to toe the line. But they said the outcomes were better. And you heard just a few moments ago before lunch when I put Ms. Sater on the stand, the defendant on the stand, and asked her, isn't it a fact that the RN scores on NCLEX first-time passing have plummeted 30 points since my client was terminated? And her response was, oh, that's sort of a trailing indicator. Okay? Well, ladies and gentlemen, think about this for a minute. A student who took a test for the first time in July of 2014 would not have even been a student at AIAM when my client was there. And in any event, this leads into the defendant's whole proposition, and that is that Tamar Gilson was responsible for everything. 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 And if she didn't do it tough, we're not going to help her. It's her job. Now, I'd like to address just one more consideration that I'd like you to think about. You've heard testimony and you've seen the defendant on the stand for several hours in this case. Why would the defendant actually promote the impression to you that she was incompetent? Because that's the impression she gives, right? She's incompetent. She doesn't know the number of students that she has. She can't answer this question or that question. She doesn't understand this. That's below my pay grade. Why would someone get up on the stand and promote the idea that they're an incompetent operator even if they're a half owner of the company? consider this. Proof of age discrimination requires me, as the prosecutor, to prove that there was an intent to discriminate on the basis of age when she made the decision to fire Tamar. Now, if you posit yourself as an incompetent, detached executive, then you hope that you folks on the jury will say, well, she couldn't have had that intent because she was just floating around out there with the granola crunchers. So, consider it, ladies and gentlemen, consider it, because did it seem detached to you when she admitted that in October she overrode the decision of the faculty to raise the standards, and then 2 more times before the end of the year lowered those admission standards again? Did that seem detached to you? Was she out of touch when she fired Chip Elam and took over his position? Was she out of touch when she fired Denny Griffin and replaced Denny Griffin with Elaine Hyatt? Was that out of touch? Hardly. Wayne Landrum has testified that the defendant was quite open about her attitude and her motives for firing Tamar. She was too old for that job. And when you consider the testimony that, in fact, no, we weren't, and I had good reason to do what I did, think about this. I asked the defendants to present any document they could find that would support contemporaneously that they had some concerns about Tamar, not just concerns, but Tamar was forgetful and confused and incompetent. Produce a single document from that period of time, a note, an email, a memo, and what do we have? 0. Ladies and gentlemen, this is what's called the Jamie Dimon defense. Jamie Dimon is the CEO of a bank called J.P. Morgan. You may know J.P. Morgan. It's one of the 4 banks that tanked our economy when they played around with our mortgages in 2008, destroyed so many lives. 4 years later, Jamie Dimon's bank lost $6.5 billion playing around with money again. 6.5. That's 2012, 2 years ago. And finally, the Senate decided that Jamie better come down to Washington and explain. And so they called him down to a committee to explain. And when Jamie Dimon got in front of the committee and raised his hand and swore to tell the truth, you know what he said? He said, it's only $6.5 billion, and that's way below my pay grade. I didn't have any idea about that. I'm so high in the Ethereum, I don't even know those things. And oh, by the way, we did fire the person responsible. And folks, there's a couple differences between Jamie Dimon's company and AIAM. One of them is that there's 65,000 employees. And so somebody might think, well, it is possible he didn't know that $6.5 billion was being taken. There are 59 employees at AIAM. The second is this. Jamie Dimon, despite the fact that he's the CEO, he doesn't own half of J.P. Morgan. I think he testified a little differently to the Senate if half of that $6.5 billion came out of his pocket. But that's what the defendant's asking you to believe, that she's a half owner, that she's the driving force behind the company, but she really doesn't know what's going on. Now, what does the record say about the lies that she told to OBN? This is a summary of what all of those documents, Exhibit 5 and the other testimony is, that after discharging Tamar, neither she nor Hyatt paid any attention to this coming report deadline, and they missed it, and Jody Hostetler called her, and suddenly the school's precarious position became well aware to the defendant, and she responded by saying that Tamar was forgetful, had forgotten the report, and she was concerned about Tamar's functioning as a nurse. And then following the law, Hostetler, upon that information, instructed her to file a disciplinary complaint. And all of that's in evidence. It's all been proved. Ladies and gentlemen, The defendant claimed that the only reason she filed this report was because Jody Hostetler told her she had to. This is Jamie Dimon defense again. Jody Hostetler testified she'd had never said anything about filing a report until she heard from Diane Sater that Tamar Gilson was so screwed up that she was concerned about her functioning as a nurse. Now, 4 months later in April, the defendant compounded those allegations, what I call lies, in the letter that we went over, Exhibit 5, many times. And in that letter she said the same thing that she says here on the stand, and that is, I didn't tell Tamar Gilson the truth about why I was firing her because I didn't want to humiliate her. I didn't want to humiliate her. And then she went on to humiliate her and humiliate her and humiliate her. I'm almost done. You'll be proud and happy to know. May I have the... Your Honor, please. There are two...
You're going to need to turn the lights on. I don't think the machine is
Sorry,
on.
Your Honor. There are two items of evidence I'd like to go over with you, and then I'll talk to you briefly, chat with you briefly about what justice is in this case, and then I'll turn this over to Ms. Miller. I want to focus your attention on two instances because I think these focus everything in this case. In February of 2013, Diane Sater got a copy of Exhibit 10, which is the email that Tamar Gilson had sent to the Ohio Board of Nursing. Around April the 1st of 2013, Diane Sater got a copy of the age charge that was administratively filed. Right there. So she had these two documents. Immediately after that, as you heard Dwayne Landrum testify, that means defendant, she called Dwayne Landrum and Linda Fleming Willis into this meeting. And you remember Dwayne Landrum testifying that she said, the defendant said, Tamar Gilson's coming after the school. Now, he knew nothing about this email, and he knew nothing about this age charge. But she said, Tamar Gilson's coming after the school. Now, the next thing that the defendant said was, I need you to come up with instances where she's forgetful and confused and incompetent, because Jody Hostetler needs this information to show that she's too old. And you'll recall that in her testimony on Thursday, I specifically and finally asked the defendant, this is what Dwayne Landrum said. Did you or did you not tell him that? And you remember what her answer was? I don't remember. Would you think that anyone presented with that question who could truthfully say an answer would say, under those circumstances, I don't remember? Wouldn't the answer be, no, I never said those words, and Dwayne Landrum's lying? However, there's one other thing you want to think about, and this is why I suggest to you that this entire meeting, this entire encapsulates, is this woman right here. I'm sure that Ms. Miller is going to get up after I'm done here and suggest to you and talk to you about how Dwayne Landrum is a disgruntled employee and he can't be believed. There were 3 individuals in that meeting One of them still works for AIAM, Linda Fleming Willis. If you folks wanted an independent witness to come in and say, oh no, that never happened, why didn't we see Linda Fleming Willis? Finally, there was a good deal of testimony on Thursday and yet again this morning about this document. This obviously is the key document. This is the report that AIAM blew and that commenced this whole sordid mess. This is the report that was due December 21st, that's dated December 27, 2012. Now you heard Elaine Hyatt get on the witness stand on Thursday and on cross-examination, actually in direct, introduce an email, Defendant's Exhibit N, which was an exchange between she and Diane Sater supposedly in April, where they're talking about the fact we were told by Tamar Gilson we cannot use your signature here. And so we sent an unsigned report to the board. Remember her testimony? And then I asked, where's the report? It's back at AIAM. And where's the emails that prove you did all this exchange, and where are they back at AIAM? And they've never been produced for you in this case. Just believe Elaine Hyatt. Believe her because why? Why? But there's more to that story. Because this morning, Diane Sater got on the witness stand and was compelled to concede that under oath in February, she had testified to me and a court reporter with her hand raised, I'm telling the truth, that this is the document that went to the board. They submitted a document to the board. You either can believe Elaine Hyatt or you can believe Diane Sater, but you cannot believe both. And I submit to you this, that if there is a report that's in the bowels of the Ohio Board of Nursing that doesn't have my client's signature on it, I think it would have been produced here instantly. Because what have they done? What does that tell you, ladies and gentlemen, about credibility and truthfulness of people who will take a woman's name and put it on a report, falsify her name, and send it in as an official record that she is personally liable for because she's the NPA? I think we'd all be happy to hear Ms. Miller explain to us that question. Ladies and gentlemen, I close by turning to what justice is in this case, and it's civil damages. It's money damages. We can't turn back the clock. We can't take away all those horrible things that were said about Tamar Gilson, her being essentially a senile old lady, but we can compensate. You're going to see there are two components to compensation, and the first is income that Tamar Gilson lost. And you have Exhibit 36, 37, and 38 in front of you, and Tamar Gilson testified about it. You can take it back and look at it, and you decide what you want to do with it. But she's calculated that she has lost and will lose up till December 15th of 2015 for $240,080 as a result of her termination. You make the decision. The most significant thing, though, is what are called compensatory damages, intangible damages, damages for such things as humiliation, damages for the loss of your name. You know, Shakespeare said it best 400 years ago. Who steals my money steals trash. To something, nothing. It was mine, 'tis his, has been a slave to thousands. But who filches my good name, robs me of that which enriches her not and makes me poor indeed. and makes me poor indeed. And you will hear, I'm sure from Ms. Miller, that everything that the defendant did is confidential within the Board of Nursing, and therefore it can't be as serious as all that. Okay? Think about it. A wise man said it takes 20 years to build a reputation and 5 minutes to ruin it. And that's what was attempted here. So I suggest to you, ladies and gentlemen, that the amount of money that is appropriate for the intangible damages, that you levy that amount of money for Tamar Gilson in the amount of $250,000 on top of the income loss, and then you will have done your job. I'll speak to you a few moments after Ms. Miller, but I thank you for your time and listening to me. Thank you.